とうございます。本日、このウェビナーの、司会と、あと、進行と、全体の、いただく、その、元法律事務所、弁護士の西山陽介と申します。皆様、よろしくお願いします。本日はお忙しいところ、本セミナー、ウェビナーに、ご参加いただきまして、誠にありがとうございます。では、早速、ウェビナーの内容に入っていきたいと思いますので、画面をシェアさせていただければと思います。はい。今、本日の、ウェビナーの、スライド資料の表紙、フロントページを投影しているのですが、見えていらっしゃいますでしょうか？
はい、大丈夫です。
はい。藤野様、ありがとうございます。では、早速、本日のウェビナーですが、先ほど藤野様からも、ご説明いただきました通り、メキシコホームの最新動向ということで、今回、各論編第2回ということで、ロードホーム編の説明で、ロードホームの中でも、つい先日、6月に、交付、施行された労働搾取禁止規制、こちらの改正がありまして、その改正法が、先日、施行されましたので、そこも中心に、労働法務上の重要な点に関して、説明をする機会とできればと思います。では、早速次のスライド。こちらに、本日お話しする内容の要点というか、トピック記載しています。まず一つはその規制っていうのがどのようなものなのか、概要。で、もしその規制に違反してしまった場合には、どういう制裁、あるいはペナルティ、そうですね、どういった結果が待っているのかということに関して説明をします。で、3番目、そういうものの、そういった不都合、残念な結果にならないために、メキシコで、オペレーションをする各企業様、どのようなことをする必要があるのかというところに関してもご説明いたします。で、最後、このような対応をするのが望ましいっていうのは、網羅的に、可能な限り網羅的に、このウェビナーで説明するところではございますが、特にここは、こういう場合には気をつけてほしいというレッドフラッグ事項を、4点目として説明し、残る時間の、次第で、適宜質疑応答の場を設けられればと思います。で、ここからは、次のスライドからは、ベガーゲレロの、オツィエル弁護士とハビエル弁護士が、英語で、プレゼントーションマテリアルを使って、解説を、していくのですが、適宜、その、各トピックの終わったタイミングで、私の方から、再度、和文のスライドが表示されますので、それこで、彼らが説明した内容を、簡単に要約して、いければと思います。Hi, Otia and Javier. As we discussed earlier, so from this side, I will hand over the control of the presentation material. So you will share your own screen and start your presentation of the new anti-human trafficking law and labor regulation. Thank you.
Thank you, Yosuke. Thank you. Good morning, everyone. My name is Osiel Guerrero. I am the managing partner at Vega Guerrero y Asociados. Vega Guerrero Asociados is a Mexican law firm who advises mainly foreign companies doing business in Mexico. First, I would like to extend my sincere thanks to Yosuke for all his efforts and his support to make possible this event. Also to Anderson Mori and Tomotsune for receiving us some months ago in its offices in Tokyo. Actually, this meeting it's part of this discussion that we had in our visit to Mr. Yosuke in his office in Tokyo, Japan. Thank you, Yosuke, one more time. And also thank you, Tokyo Marine, for allowing us to talk with all of you this morning. In Mexico, at this time, we have a lot of labor changes. Maybe 6 years ago, that a new party in Mexico entered in charge in the president of the republic. There was a lot of changes in the labor law. Last year, or during this year, we have a specific change in anti-trafficking law that is the topic that we will discuss today. So I would like to introduce my colleague Javier Ambris. Javier is also part of our law firm, and he is in charge of the litigation, labor, and employment team. So I want to ask Javier to start with the presentation of this topic, with the overview of this topic, because we think that for all the participants of this event that have interest or have operations related in Mexico, it's important to understand the overview of this topic, because this topic, it was a lot of discussion in media last month because the employees said that after this reform, how can I say that? A company cannot ask to its employees to work overtime. So during this session, we will be discussing about this topic, and we will be discover if it's true or is false, this affirmation from some people. So Javier, please go ahead.
Thank you very much, Josiel. I would also like to thank our host, especially Yusuke, and express that it's a pleasure for me to be sharing this presentation with all of you. Now, everybody can see the slides, right? Okay, perfect. Okay, now the reason this reform has been so discussed in Mexico is the media impact it has had, especially due to the use of delicate terms like labor exploitation. However, through this presentation, you will see that this reform could even be considered alarmist, and is not necessarily simple or feasible for an employer to be considered or convicted as an exploiter of people. That said, it's important to note that this reform took place on June 7 in this 2024, where the general law to prevent, punish, and eradicate crimes in relation to human traffic and for the protection and assistance of victims of such crimes. For now, I refer to this law like human traffic law, for make it simple for everybody. This law was modified in the last June 7, like I said. The primary objective of this reform was to add a new section to the Article 21 from this law, which defines the activities that will be considered for labor exploitation. The added section, the Article 21, stipulates that working hours that exceed those permitted by the law, referring to the federal labor law, must be considered as labor exploitation. It is important to highlight that this is criminal legislation, not labor legislation. The human trafficking law is a penal legislation, not a labor. So that's very important to highlight. That is that the act, if completed, must be prosecuted and investigated by the Attorney General Office of the Mexican Republic and will be resolved before criminal courts in Mexico, no labor court. You will see there is no labor authority authorized to investigate or resolve such conflicts. So we continue. the objective of the law. Before delving into the specific modifications, it is essential to clarify the objective of the law to prevent human traffic. In its initial articles, it is clearly stated that one of its objectives is to prevent the abuse of power, which we can understand as the exploitation carried out by the active subject of the crime, arising from a relationship of family, emotional trust, or, as in this case, the labor power that have the employer before the employee. This labor relationship must involve a dependency of subordination from the victim to the perpetrator, which directly applies to the topic at hand. Additionally, like any law, of every law, the law to prevent human traffic must comply with a series of clear specifications regarding its scope. This law establishes competences and coordination methods to prevent, investigate, prosecute, and punish traffic and crimes, both by the Mexican federal government and the states that make up the Mexican Republic. Moreover, it determines the applicable criminal procedures from this type of crime and establish effective mechanisms to protect the life, dignity, and integrity of individuals, in this case, the employees, in line with the trend in Mexico in recent years, especially in criminal matters. The comprehensive reparation of damage to victims has been prioritized over the punitive deprivation of liberty of the accused. Since the criminal reform, that is a very important reform in Mexico from the 2008, which provoked a radical change in the federal and local justice system in Mexico. The aim is to ensure that the victim is compensated either through economic, psychological, or social benefits before resorting to the imprisonment of the offender. The person who committed the crime is first obliged to repair the damage of the victim, and after they go to prison in the case that we present. So we continue. Okay. What was reform? Then straight to the point, I inform you that this human traffic law has been in effect for several years, having been published in the official journal of the Mexican Federation the last June 14 of 2012. We have this law for at least 12 years. In that moment, over 12 years ago, its Article 21 already stipulated three practices that could be considered labor exploitation. The first one, when the employer forces their employees to work in dangerous or unhealthy conditions without providing the necessary protections according to labor legislation. That's the first one. The second one, when there is a disproportion between the amount of work performed and the payment given to the employee for that work. And the third case, when employers pay salary lower than the minimum wage established to Mexico. However, it was only after the aforementioned reform in June of this year that a new section was added to the Article 21, the fourth case. This section stipulates that it will also be considered labor exploitation when employers work hours that exceed those permitted by the law. These form assumptions will be punished with prison sentence of 3 to 10 years from employers and fines ranging from 5,000 to 50,000 days of salary, which amounts approximately like 28 to 280 pesos, 280,000 pesos. As you can see in the wording of this 21 article, it is clearly established that there will be labor exploitation when a person unjustifiably obtains an illegal economy benefit through the work of others and through practices that violate dignity, that violate human dignity. For this crime to be configured, 3 requirements must be met. The first one, that it's demonstrated that the employer obtained an unjustifiable benefit. The second requirement, that such benefit was only obtained for illegal practices. And the final requirement is that it's demonstrated to a penal authority that the benefit was obtained through acts that violate the dignity of the workers, of the employees. Therefore, it is not easy to prove an accusation in the matter of labor exploitation, as it requires proving all these 3 elements. So,
Thank you, Javier. Yes, I will start the summarizing explanation with this slide. はい、ありがとうございます。では、ここで私がこのスライドを用いて、今、ハビエル弁護士が説明してくれた事項について簡潔に、ごくごく簡潔に説明します。ただ、その前に、今、ライブで、いくつかというか、ご質問いただきまして、このプレゼンマテリアルをもらえるのかというご質問いただきまして、はい、後ほどアンケートがありまして、そちらご回答いただいた方には、この、プレゼン資料、共有することとなってますので、ぜひご協力いただければと思います。そうですね、アンケートいつもご回答いただいて、非常にモチベーションになってますし、そこでいただいたご指摘は、深く反省材料というか、検討材料としていますので、ぜひお願いします。あとは、今後どういったセミナー、事項、テーマとか、あるいはどこの国に興味があるとかっていうことも、遠慮なくご記載いただければと思います。すみません、ちょっと余談というか、本論と外れるんですが、その点を、では、こちらの、内容を説明します。で、今、ハビエル弁護士からありました通り、改正法は、そもそも人身売買を禁止する、刑事法の一部として、定められています。で、ただ、先ほどの説明もありました通り、かなり、労働法に関係しています。それ自体は労働法ではないものの、その労働搾取禁止規制を遵守するためには、労働法で、メキシコは労働法は連邦レベルで規制されてますので、連邦労働法を理解する必要があります。なので、後ほど、落ちている弁護士の方から、労働法上の規制内容っていうのがどのようになっているのかを、後半のスライドで説明いたします。で、この労働搾取禁止規制、あるいは人身売買を禁止する法律っていうのは、権力の乱用を禁止していまして、で、雇用の文脈では、使用者と被用者の間に権力関係が認められるので、そうですね、そういった労働に関する搾取も禁止されます。で、具体的には複数の類型がありまして、これまでもこの、労働搾取禁止規制っていうのは存在してました。ただ、既存、従来は3類型だけだったのが、2024年、6月より新たな、類型も追加されたということです。で、具体的には、これまでは、危険または不健康な環境または条件で、適切な措置とか安全配慮措置とかを講じないで、不正規則な指導をして労働強制することとか、あとは、ものすごい、大変な、あるいは物量的に、過酷な労務に 対して、対価が不当であって、もう本当に如実に不均衡があるような場合、あるいは法定賃金を下回る賃金支払いがなされた場合、このような三類型が、労働搾取に当たるとされていたのですが、今般、法律で許容された労働時間を上回る労働の強制、これも、搾取と、に当たり得るということで、刑事責任の対象になることになりました。で、じゃあ、その法律で許容される労働時間って何かというと、連邦労働法で規定がありますので、追ってのスライドで、解説できればと思います。このスライドを、用いた、解説は以上です。Thank you very much for your patience, Javier and Otero. So, you can proceed to the next slide to resume your presentation.
Thank you. Okay, we continue. Okay, now we're talking about the relevant criminal aspects of this reform. Basically, this was a modification made to Article 21 of the Human Traffic Law, which, as I mentioned, had existed for over a decade. However, this new section generated doubts and uncertainty both among employers in Mexican territory and among foreign investors. Therefore, this type of exercise is extremely beneficial as it helps clarify the scope of legislation. Now, before entering into a specific analysis of the wording of this reform, it is important to highlight a couple of relevant aspects in criminal matters. In Mexico, there is the figure of preventive detention, which is the deprivation of liberty of a person accused of a crime and linked to a process. This means that a judge has determined that although the person has not yet been declared guilty, there are sufficient elements to conduct a trial against them. When a person is linked to a process, the judge has the authority to impose the preventive measures to prevent the person from fleeing or evading justice. One of these measures is preventive detention, which is only applicable to a limited list of crimes. However, labor exploitation is one of these crimes where this measure can be implemented. So employers who are linked to a process for this crime can be subject to preventive detention. Furthermore, due to the nature of the crime, labor exploitation is pursued ex officio. This means that it's not necessary for there to be complaint from a citizen for the Attorney General's Office of the Public Prosecutor to initiate an investigation. It is enough for these authorities to have knowledge by any means of the probable commission of the crime to begin inquiries, in this case, the labor exploitation. Lastly, it's important to clarify that it is a federal crime. The labor exploitation is a federal crime. So the Attorney General's Office of the Mexican Republic is the authority responsible for conducting the investigation. It is also relevant to mention that the penalties I mentioned earlier can increase by up to an additional half when acts of labor exploitation are committed against pregnant women, persons with physical or psychological disabilities, and minors under 18 years old, and elderly person or members of indigenous community or autonomous communities. Okay, about the criminal liability of legal entities. Now, it is important to note that Mexican criminal legislation also established responsibilities for legal entities, meaning companies or entities and not just individuals. Therefore, a company can be subject to the economic sanctions mentioned earlier, which is a noteworthy situation. This is stipulated in the Federal Penal Code, which states that when a representative or member of a company commits a crime using the means provided by the company or under the protection of this company, various sanctions may be imposed in judgment, which we will see shortly. Other consequences that can be applied to a legal entity in criminal matters include sanctions such as the suspension of the company's activities, the closure of premises or establishments, temporary disqualification, judicial intervention to safeguard the rights of the employees, and even the dissolution of the company can be one of these sanctions. I want to reiterate that we are talking exclusively about the criminal sphere, not the labor sphere, that we'll see on the next part of the presentation. And this regulation is framed in that area, in the criminal law area. However, it is important to point out, although these consequences exist, it's extremely difficult in practice of this reform. It is time to go into detail about what pertains to our specialty, the labor aspect. So, therefore, if everybody is okay with that, I will pass the word to my colleague, Licenciado Giel, to continue with the presentation, and he's talking about all the labor reference and the labor consequences and legislation of this reform. So here I will pass the microphone for you. Oh,
Thank you,
but
Javier. Yeah. Before OTR starts his
before
part,
that,
I will summarize what you just explained about the consequence of the violation. But no worry. Thank you very much. はい。今、ハビエル弁護士の方から、この、刑事法である、労働搾取禁止規制、これに反してしまった場合の帰結というところに、ご説明してもらいました。で、まず、こちらのスライドに書いてあります通り、罰金及び禁錮というところで、この、原則というところで5000から5万 UMA の罰金、または3年から10年の禁錮というところなんですけれど、この、UMA っていうのがウニダデ・メディダ・デ・アクチュアリザシオンって言いまして、で、これは経済単位で、メキシコでは、この法律だけではなくて、例えば独禁法であったり、あるいは、そうですね、刑法一般であったり、その刑事法あるいは行政法上の制裁、罰金、制裁金、課徴金、そういったものを、日本の場合って、いくらいくら以下の、罰金に処するみたいな感じで、定額制で、法律に明記してるんですけれど、メキシコ、あと他の、中南米の国もそこそこあるんですけど、インフレがあるからですかね。なんか毎年、額が変わるように、経済単位を設けて、それで法律で定めるということにしてます。すみません、参加者の方の中には、この説明繰り返し聞いてるかもしれないんですけど、で、2024年、現在、この UMA っていうのは、1 UMA が108メキシコペソ程度で、大体今って、もしかしたら 8.5 円ぐらいかもしれないんですけど、1メキシコペソ、8円で換算すると、上限である5万 UMA っていうのは、4350万円程度です。で、個人に対してはそういった罰金や禁錮で、これが原則なんですけど、先ほどハビエル弁護士からも説明ありました通り、一定の人種であったり、先住民であったり、あるいはアフロアメリカン系の移民であったり、あるいは妊娠している女性、未成年者、障害者である従業員に対する労働搾取の場合には、さらに、ある程度上乗せになった罰金制裁ということが予定されています。で、繰り返しになりますが、この法律自体は刑事法で、刑事訴追となりまして、管轄当局は検察当局です。 で、重要な点として、職権で調査が開始されます。つまり、申告罪的なものではなく、そのため、被害に遭った労働者、私はこんな搾取を受けましたっていうような、通報とか告訴、そういったものは不要です。で、あともう一つ、今、先ほど、個人に対してはと言ったんですけれど、連邦刑法が、両罰規定の定めを設けてまして、ある一定の要件を満たすと、本人も処罰対象となって、具体的には、罰金とかと、合わせて、業務停止であったり、公共入札資格の、喪失または停止、あと、最悪の場合、これは死刑判決に近いものなんですけど、もうその解散命令、そういったものも、下される可能性があります。以上、違反行為があった場合の否決とか生じ得る責任についての説明をいたしました。Otian, thank you very much for your patience. So you can proceed to the next slide so that you can start your explanation about the labor aspect.
Thank you, Yosuke. Well, as Javier mentioned it during his intervention, the reform states that labor exploitation occurs when an employee work hours exceeding those stipulated by law. So for this reason, I will proceed to explain the labor implications of this reform. It's important to clarify the legislation surrounding working hours in Mexico. The recent reform to the anti-trafficking law prohibits work beyond the legally stipulated workday limits. For this reason, it's important to review, to check what is about the work days in the labor law in Mexico. So when you see federal labor law, that is the legislation that regulates all the labor relations in Mexico, this law sets three kinds of work days: daytime, nighttime, and mixed workday. Daytime workday is that starts at 6 a.m. to 8 p.m. The nighttime workday is from 8 p.m. to 6 a.m. And the mixed workday is a combination of daytime and nighttime that does not exceed 3 hours and 30 minutes. If it does, it is considered a full nighttime workday. Additional, the federal labor law sets a maximum duration for these workdays. In case of daytime, the law says that it will be 8 hours. For nighttime, it will be 7 hours. And for mixed, it's 7.5 hours. Also, the labor law states that in Mexico, as a basic right to the workers, for every 6 days worked, they have the right to rest for one mandatory day. It's important to make a parenthesis at this moment, just to share with you that in Mexico, there is a discussion, an important discussion in the Congress of Union, the Chamber of Deputies, and the House of Representatives or Senate of the Republic about the reduction of the work days, of the weekly work days. As I mentioned it, currently the labor law says that the employees could work six or for each 6 days of work, they have the right to rest one day. The proposal is to reduce 6 days to 5 days. So in case the reform passes, the work days will be reduced, because at this moment, the weekly work hours are for daytime workday 48 hours, as you can see in the slide, 45 hours for the mixed shift or mixed workday, and 42 hours for the night shift. So, as I said, if this reform will be approved during the next few months, the work days will be reduced to set that the daytime will be 40 hours weekly. The nighttime work days will be of 35 hours, and the mixed work day will be 37.5 hours. Close the parentheses, and Javier, could you pass to the next slide, please? Now, based on this legal framework, any hours worked beyond the standard workday are considered overtime. It's very important to mention that the federal labor law provides a regulation to work overtime and to receive the payment for this overtime. The federal labor law allows for overtime under certain conditions. It's important to highlight these certain conditions because the labor law also mentioned that workers are not engaging in illegal activity when they work beyond the ordinary hours. So if you remember, Javier told us that this reform of the anti-trafficking law mentioned that the exploitation, labor exploitation occur when a person obtains directly or indirectly an unjustifiable benefit, economic or otherwise, in an illicit manner. This part, illicit manner, it's very important because if you see all the framework and all the text or the wording of the federal labor law, it's provided that this law allows the overtime. So not all overtime is prohibited in Mexico, and not all overtime will be a labor exploitation, because the labor law set the possibility to work overtime. Also, the law established a limit, and I want to explain this part with a detail, because the labor law set a limit of 3 hours per day up to 3 times a week. So this means that that works beyond this limit could be outside of the limit. So it's important to take care of that. In addition, it's important to say that Supreme Court in Mexico has interpreted this part of 3 hours per day up to 3 times a week, and determined that the sum of these 3 hours per day up to 3 times a week could translate in 9 hours weekly. So if the employee works up to 9 hours weekly, the company are under or on the limit of the law. So it is crucial to ensure that the employees receive appropriate rest when working overtime, so the workday remains human and not overly long. About the extraordinary circumstances, I want to say that this term is very general. So this could apply for a lot of reasons. For example, an increase of production demands, also for external situations, for example, like the pandemic or economic recession, which may necessitate extended work periods for months or even years. So the law does not provide a form that you as an employer could prove the extraordinary circumstance. So as I said, it's very general. So as a company that, or our recommendation from our law firm to our clients or companies, it's to make a registry about how is the reason, because you need overtime from your employees. In conclusion, as long as there are valid circumstances of an agreement between an employer and employee, overtime is permissible, provided it is paid as required by law. And I will explain how it will be paid in terms of law during the next slide, please. Okay, let's discuss how overtime should be compensated under the federal labor law. The labor law said that the first 9 hours of overtime in a week must be paid at double the regular hourly wage, so 100% of top of the regular hourly wage. And also, the labor law says that any hour beyond those first 9 must be compensated at triple the worker's normal hourly rate. So for this reason, and at this moment is maybe complicated to understand, because on one hand, we have that the law establishes that the limit of overtime is 9 hours. But on the other hand, we have that also the federal labor law provided a specific regulation to pay beyond of those 9 first hours of overtime. The reason is because, as I mentioned it, the first 9 hours maybe is understand that the majority of companies needs or have special circumstances to need overtime from their employees. So the beyond of first 9 hours maybe is not desirable, but the law understand that a lot of companies maybe, in some occasions needs overtime above and beyond of 9 hours. So for this reason, the law says that you need to pay with 200% of the regular wage. So at this moment, I want to highlight one more time that as you can compare the wording provided from the anti-trafficking law and the labor law is in contrast, because the anti-trafficking law established that just the labor exploitation could be when some of elements, like Javier explained it, like unjustifiable benefit, illicit manner, and through the labor of another person, subjecting them to practices that violate their dignity, such as blah, blah, blah. So for this reason, I think when the company needs overtime, it's not necessarily labor exploitation, because the labor law states that the companies, and understand that the companies needs to get overtime from their employees, and the labor law says that in case you need this overtime, you need to agree with your employee, and you need to pay for that. And if your employee are okay with work this overtime and receive the payment, everything will be okay. Okay, so Javier, could you please pass to another slide, please? Okay, so I want to share with you some recommendation that we have prepared from our perspective in order to prevent any sanction or any fine from the authority, because as we explained it, we think that this is not the end of the overtime, but this is maybe the beginning of a new form to regulate the overtime and to get overtime in our companies. So we have outlined a series of recommendations to help ensure compliance with the anti-trafficking law reforms. While this law is relatively straightforward to apply, we always strive to provide our clients with preventive and comprehensive legal advice. Here are our suggestions. First, work hour management. We suggest that ensure that overtime is only performed when absolutely necessary and not as a regular practice. So we strongly recommend to not contract, to not hire people to perform work days beyond of the limits of the law, because as I mentioned it, also there is an important discussions to reduce the workday. So if you contract an employee to perform a workday beyond of the limit of the law, maybe could be a presumption that you are violated the limits of the law. So our recommendation is to contract people just to perform the limit, the limit of the legal work days. And in case of you have extraordinary circumstance, you need to manage the situation in the best way that you could manage. Second is review of contracts and regulations. We suggest to review the wording of individual employment agreements and internal work regulations, because in many cases, contracts have clauses that prohibit overtime as a protective measure for employers. It was very common to find that all the individual employment agreements said that it is prohibited to the employee to work overtime, because as you may understand, with this clause in the individual employment agreement, you could prove or make an evidence in a trial that you do not perform overtime in your workplace. Obviously, is not maybe a proof, evidence enough for the majority of cases. A lot of labor judge does not take this clause like the last word, but it's a very common practice in Mexico that all of individual employment agreements from or before of this reform are wording with this prohibition. So our recommendation is to review that and modify, because if you agree with your employee that the employee could work overtime when the company has the necessity and the employee is okay to perform this overtime, the company could pay in the terms of law, and it will be according to the law. Number 3, documentation of requests. We suggest to establish protocols or policies to document overtime requests. As I mentioned, I think that the overtime is lawful, but it's important to document this request. Also, both that the company needs this overtime, and also the employee agree with that request from the company. We suggest that these records of the documents should be maintained as a proof of compliance with this regulation. And finally, and maybe is obvious, is the payment receipts. Ensure all payroll records, salary receipts, and bank transfer confirmations are properly maintained in the company. These documents will serve as evidence that overtime was paid in accordance with the law. So we think that by comply to these recommendations, companies should avoid complications with both labor law and criminal law, and also obviously with labor authorities and criminal authorities in Mexico. So as you can see, we, in our opinion, prevention is key in managing labor relations, especially in light of this new reform. It is critical to consult with specialized legal counsel with Mexican legislation. Obviously, our firm is at your service to provide comprehensive support and advice as needed. Well, we sincerely appreciate the opportunity to speak today, and we thank all of you for your time and attention. We hope our presentation has been clear and helpful. Please accept our warmest regards. And I want to thank you one more time to Tokyo Marine and all the companies that are participating in this meeting. Special thanks to Anderson, Mori, and Yamotsune, and obviously to Yosuke and all of you. Thank you so much. We are at your service, and please feel free to contact us in case you have any doubt, not just in this topic. If you have any doubt or any query about the Mexican legislation related with your Japanese company operations, please feel free to contact us. We will be glad to talk with you and to make a strong relationship with all of you. Thank you so much. Yosuke, thank you.
Thank you very much, Hotel. So I will just make some summarizing explanation of what you just explained. So Javier, could you please proceed to the next slide? Yeah, thank you very much. Here. はい、ありがとうございました。今、ちょっと、こちらの方から、労働法に関する説明ありまして、それも踏まえて全体的なおさらいということで、このスライドと次のスライドを用いて説明いたします。で、じゃあ、各社様においてどのようなことをすべきかというところで、まずその出発点は連邦労働法上法の、どのような法定労働時間規制があるのかというところと、それがまず出発点です。あともう一つは、各社様において従業員が、どのように勤務しているか、その勤務の実態を把握されること、この2つが出発点です。で、前者において、つまり法律上の、法定労働時間制度っていうのが、メキシコの場合、1日ごとの労働時間と、週ごとの法定労働時間が決まっています。でもう一つ、これ日本法とかなり違うんですが、日中勤務時間制度、つまり朝9時ぐらいからですね、18時ぐらいまでの間の勤務なのか、それともそれを外れた勤務っていうか、そうですね、夜間から明け方までの勤務時間、これが夜間勤務時間で、あと、それ両方にオーバーラップするような形の混合勤務時間っていう概念が存在して、で、それぞれにおける1日ごとの法定労働時間も週ごとの法定労働時間も異なっています。で、詳細、すみません、私の、手前ミスになるんですが、私がこの、労働法に関する記事を書いておりますので、こちらハイパーリンクついて飛べますので、もしご興味ありましたら、参照いただければと思います。で、 で、例えばなんですけど、日中勤務時間現在は、まず週6日制を取られていまして、メキシコでは。で、かつ、週48時間までとかなり長い、比較法的に見てもかなり、長時間労働が許容されている国なのですが、現在、先ほどオティエルの弁護士からも、説明がありました通り、上院会議レベルで、法定労働時間短縮と、あと、週6日制を週5日制に変えてよっていうような、で、48時間の週の法定労働時間も40時間とか45時間とかに、継承させようとかっていう議論がなされていますので、これはダイレクトにその労働搾取禁止規制、つまり、連邦労働法上の法定労働時間を超過する労働というところに関わってきますので、今後も、注意が必要なところです。で、あとは、もう一つの対応としては、雇用契約、就業規則において、時間外労働については定めを設けること。あとも、すでに締結済みのものに、例えば、時間外労働をしないものとする、あるいは禁止するという趣旨の規定がある場合には、かなり、これは、変更とか調整が必要となります。で、なぜかというと、そのような規定があるのに、実態として時間外労働がなされている。これはもう、強制をしているとみなされるリスクが、あるためです。で、あとは、時間外労働が提供された場合には、法は、上乗せ賃金、場合によっては2倍。で、もう週の9時間以上の時間外労働であれば3倍というような要求をしてますので、それをしかるべき対応をして、で、かつ先ほども説明ありました通り、支払いをしたらその証跡を残していただく必要があります。これは強制していないことと、あともう一つは裏付け資料をするという意味があります。Javier, could you please proceed to the next slide? はい。で、最後に特に気をつける必要がある事項、レッドフラッグ事項なんですが、これは先ほど説明したことの裏返しなのですが、従業員の実態、労働実態把握していない。これはかなり危ないところで、まず、そもそも法定労働時間を超過している可能性がある。あと、先ほど何度か繰り返してオティエル弁護士が説明してくれましたが、時間外労働は例外的に必要性がある場合に認められるべきものなので、これがコモンプラクティスになってしまっている。そういったのは非常に問題な状況ですので、そういった状況になってないかを、認識していただく必要があります。で、あとは、雇用契約または就業規則がどんな、規定を定めているかわからない。これもさっき申し上げました通り、そもそも、時間外労働はしない、あるいは、してはならないというような規定文言がある可能性がありまして、そうすると、時間外労働が提供されている場合は、これは強制だと、見なされてしまうリスクがあります。で、あとは、時間外労働がなされているにもかかわらず、その時間外労働を実現するための内部手続き、例えば申請だったり、その申請のためのフォームだったりとか、そういったものが用意されてないし、あるいは、支払い、その割増賃金払ってるのかもしれないけど、それを裏付ける証跡、ペイメントスリップ等が見当たらない。そうすると、調査とかが入られたときに、強制がなされている、あるいは、そうでないにしても裏付け資料が存在しない。というところで、なかなか弁解が難しい状況となります。以上、ちょっと駆け足になってしまったんですが、これまでの、推奨事項と、特に気をつけていただきたい事項について説明いたしました。Javier,
はい。
could you proceed to the next slide? I think we will go to the Q&A session. And next slide. ありがとうございます。
はい。西山先生、ありがとうございました。一つQ&A にですね、ご質問が届いているんですが、まさか今、西山先生が解説いただいたことと近いかとは思うんですが、はい。いかがでしょうか。まさか残業の理由を証明する記録は日々作成する義務があるのかということと、はい。
そうですね。これは
はい。
私の理解では、日々、そうですね。都度っていうのは、個々の時間外労働ごとに必要性、と、相当性等を考慮して認めるべき、つまり例外措置ですので、一応念のため、ベガーンドゲル。OCL, if I understand correctly, I think the application for the working overtime and, that should be submitted for each overtime working and kept that the evidence, I mean, the application and the receipt of such work overtime application shall be kept for each overworking. Is my understanding correct?
Yeah, it's correct.
Yeah. そうですね。はい。なので、例えばなんか契約上にもう包括承認というような形ではなくて、都度、 申請があるたびに、提出していただいて、承認手続きをとか、そうですね。で、証跡もここに残していただく必要があります。
はい。ありがとうございました。
Okay, there is a question in the Q&A box that, if you allow me, I could respond from Tojimasa Kawashima. Yeah.
Yes, that's what we've just asked to you. He asks if the record to substantiate that we are duly complying the regulation shall be kept on a daily basis, or it will be permitted by comprehensively by agreement or internal labor regulations. And I think the former understanding is correct.
I don't know that. Well, I think he refers that the reason of the overtime that I mentioned it, because I repeat that it's important to justify the extraordinary circumstance to justify the overtime. So in this case, I think it is not strictly necessary to document the reasons for overtime on a daily basis. We suggest, for instance, that a practical option is to use the Mixed Productivity Commission, which is a committee established by federal labor law that is composed of representatives from both employees and the employer. This commission can meet to analyze the extraordinary circumstances that require overtime. And we believe that documenting these meetings and their conclusions will be sufficient or enough to justify the need for overtime in compliance with the law. So in our opinion, this is a practical solution against to document daily that as a company you need overtime. So as I mentioned, maybe the increase in the demand or the supply chain that your company is participated needs more products that you are producing at this moment. Any situation like that, I think we could discuss in this Mixed Productivity Commission in order to have the document and the approval from the employees. Also, if your company have a union, we also suggest to make a meeting, for example, with the union and agree on the terms about of this circumstance, this extraordinary circumstance, to get overtime from their employees.
I see. Thank you very much. So I understand that, for with respect to the reason for permitting the working overtime, I think it should not be determined case by case, for each cases. But my understanding is that, for the record of the evidence, I think for each time the application for overtime working should be submitted and kept. Is my understanding correct?
Could you repeat, please? Or I don't know if Javier gets the answer.
Yeah, I think that it's not necessary to record every extra hour of overtime work. We need to attend to the specific case. And if we have the labor contract that establishes the agreement between the employee and the employer, I think that is enough to justify the overtime worker. No record enacts every time that a worker worked overtime. I think that the answer is from that side.
Thank you very much. そう、すみません。ちょっと長くなったんですけど、労使双方から、補正員から、構成される委員会によって、いわば一種のこういった場合には累計的に、オーバータイムを認められるっていうような、決定をして、で、それを記録に残すことで、都度の、 申請を避ける手法も一応あって、プラクティカルの手法として採用されることもあるということでした。
はい、ありがとうございます。ではですね、西部さん、まだお時間大丈夫で
私
し
は大丈夫なんですけど、ゲレロの弁護士も多分大丈夫だと思うんですけど、はい。
じゃあ、少しちょっと、追加で質問いただいておりますので、一旦ここでちょっと中締めさせていただいて、じゃあ、可能な限り少しQ&A にですね、お答えいただければと思いますが、よろしいでしょうか。
はい。
はい。はい。ではですね、皆様、すいません。お時間になりましたので、一旦ここで、セミナーの方は終了させていただきます。講演資料に関しましては、アンケートをお答えいただいた方々に、提供させていただいておりますので、ぜひ、最後にですね、アンケートの方を、ご回答をいただければと思います。アンケートは、退出ボタンをクリックいただくとアンケートに続く設定になっておりますので、ぜひご協力をお願いいたします。それでは、本日は貴重なお時間、セミナーにご参加いただきまして、誠にありがとうございました。またの皆様のご参加をお待ちしております。まだ、お時間ある方はこのままですね、視聴を続けていただければと思いますので、よろしくお願いいたします。では、西山先生、少しQ&A にも、ご質問いただいている件でございますが、一つちょっと私を見上げますと、実労実、実績の把握についての質問ですということで、これ実労働実績の把握でしょうか。管理する最小単位はありますか？例えば5分以内の差は許容するとか、このあたりメキシコではいかがでございますでしょうか。
法律上特にその管理する最小単位が認められているわけではないのですが、例えば、ただ一方でその5分以内の差は許容するというような定めも、例えば切り捨てとかそういった定めもないです。で、そこら辺どうしてるのかっていうところなんですが、私の理解だと法律上形式的な面では、一応は1分でも過ぎたら、オーバータイムというところなんですけれど、そこら辺どうなのかちょっと確認します。OGL, you know, to, you know, what we are wondering if, for example, some employer work on for the daytime working time, works for 8 hours and 1 or 2 minutes. Does that constitute working overtime? For example, they're just passing 1 or 2 minutes. It's very technical point. Or is there any, de minimis exemption? Or I think there is no.
The Supreme Court determines in cases like that you need to sum the minutes of the week and you need to pay I don't know, if the minutes complete an hour, obviously you need to pay the hour. If not, maybe you need to pay the proportional part. So, but the account could be weekly. So, and I think this is related with another question that it is in the Q&A box that someone asked us what if an engineer worked 5 hours extra for the machine break? We pay 100% for the first 3 hours and 2 hours for 200%, and the answer is no. Because also one of the interpretations from the Supreme Court establishes that you need to make you need to sum the time that the work time weekly. So in case that your employee has 5 hours in total, you will pay just 100% over the regular hourly rate. So the Supreme Court determined that there is not that maybe the one day the employee works 5-6 hours obviously is not the desirable, but is possible, no? So I would like to confirm or to share with you that you need to make the weekly account.
I see, I see. So, in the case of fragmental working overtime, for example, in one day, for example, on Monday, some, employees work 5 minutes overtime, and the next day work 10 minutes, and those, fragmental working overtime accumulates for all the weekdays. And at the end of the week, we see that there is, 2 hours working overtime. Then the employer should pay, 2 hours working overtime pay.
Yeah.
That's but
Yeah.
But the point
Correct.
is that, even when each day it was very fragmental, 5 minutes or 10 minutes, that should be recognized as working overtime. Okay, thank you very much. And another question is that, even when there is 5 or 6 hours working overtime, but at the end of the week, the working overtime doesn't exceed 9 hours, there is no need to pay triple hour overtime pay.
Yeah, correct.
Thank you very much. はい。今、2点目だけなんですが、3点目の、ご質問にも関連して、説明いただいたんですけれど、まず、最小単位はなくて、で、5分程度の、あるいは5分以下の、超過労働であっても、これは、認識をしなければなりません。で、ただ、その都度、それを、に対して払うという観念の仕方ではなくて、1週間、で、振り返って、例えば5分が、5回とか、あるいはその5分、10分とか、いくつかその週の労働が積み重なって、それが1時間だったり2時間だったりしたら、それは2時間の超過労働として認識して、しかるべき超過手当を支払う。そういった考え方と運用がなされます。で、あともう一つのご質問、英語でいただいた方のご質問なんですけど、1日に例えば5時間を、の超過労働があったとしても、それが例えば週の終わりに振り返って9時間枠内に収まっていれば、その、換算としては2倍の、5時間に対して2倍の、給与を支払うべきだって、つまり、1日3時間を超過した2時間分に関して3倍の、超過手当を支払わなければならないという考え方はなされません。
はい。ありがとうございました。西山先生、このチャットにいただいているご質問も大体
そうですね。
お答えいただいたところでございますよね。
これとはまた別の、ただ
別
これは
ですかね。はい。
先ほどオツィエル弁護士からもありまして、これはかなり法律に疑わしいっていうか、そう言ってもしょうがないんですけど、ご指摘の通り、9時間までにせよという規定になっている週の、超過労働時間、時間外労働時間は。それはそうなんですけど、一方で、9時間を超えた部分に関しては、3倍の手当を支払えっていう、もう当然じゃないんですけど、そういうことが行われることを想定しているような定めになっている。すごい矛盾なんですけれど、で、オツィエル弁護士としては、デザイアボーではない。全く好ましくはないし、避けるべきなんだけれど、なされてしまったら3倍の手当を支払う。で、それをすることが許容されるのか適法なのかっていうのはかなり難しいところであって、そもそも法律が週9時間以内に時間外労働を収めなければならないというふうに規定している以上、それを適法と断言することはできないんですが、そのようなことが実務上なされていて、で、してしまったら、ただ一つ言えるのは、してしまったら、しかるべき手当として3倍の手当を支払う必要がある。で、これもしないと、超過で働かせた上に手当も支払ってないっていうので、かなり厳しく見られる。なので、繰り返しになりますが、週9時間を超えて時間外労働させることは全く好ましくなく避けるべきです。ただ、してしまったら3倍の給与を支払う。これはもうマストとなります。回答としてはこのような形になります。
はい。ありがとうございました。以上で大体今いただいている質問、すべてお答えいただきましてありがとうございました。はい、ありがとうございました。それではですね、少しちょっと時間延長させていただきましたが、これにて、本日のセミナーはですね、終了させていただければと思います。もし、まだご質問いただけてない方いらっしゃいましたら、アンケートの中でも、コメントをですね、ご入力いただく箇所ございますので、ぜひそちらも、ご入力いただければ可能な限り、先生方からもですね、回答いただけるかと思いますので、よろしくお願いいたします。では、本日は貴重なお時間ご参加いただきましてありがとうございました。これにてセミナーは終了させていただきます。どうもありがとうございました。
ありがとうございました。Thank you very much for your time, Osia and Javier. Thank you for your presentation.
内田さん、羽生さん。
Yosuke.
Thank you.
Thank you,
Thank you
everyone.
for attending to the seminar. Thank you.
Thank you. ありがとうござ
Thank
い
you.
ます。
ありがとうございました。今、ズームの、チャットの方にもですね、皆様方にアンケートのリンクも、ご案内させていただきましたので、そちらの、リンクか、もしくは、退出ボタンを、クリックいただければ、アンケートに、続く設定になっております。また、別の、テーマでですね、メキシコ関係、セミナー内容固まりましたら、また皆様方にも、ご紹介できればと思いますので、その際はぜひ、ご参加をいただければと思いますので、よろしくお願いいたします。では、まもなくズーム終了させていただきます。西山先生もありがとうございました。では、失礼いたします。
ありがとうございました。失礼いたします。